the two fields I follow very closely recently are artificial intelligence and competition law, and innovation theories of harm in merger control. The innovation theories of harm in merger control bit could actually do well by there being better mechanisms of legal certainty being introduced. I wouldn't say the same thing for the AI bit because we're in the exploration phases at the moment, and there isn't that much of reason to talk about legal uncertainty as the enforcement is not very prevalent. But the innovation theories of harm in merger control is becoming more and more, and not only in digital, but also in pharma, in other sectors, it's becoming more and more disturbing, I think, for businesses in the sense that it is really becoming difficult for them to anticipate which transaction would run into a problem and which wouldn't. Also, some cases feel like they might be dressed up as innovation issues after a more traditional unilateral concern is articulated in that case. So when you read the recent decision of an authority, you're seeing a lot of language on innovation, but actually the discussions weren't revolving around innovation issues to begin with. So it's, I think that is one of the fields where we will, over time, have to go back to a neutral starting point rather than assuming that mergers would be reducing innovation and, being defensive too quickly, maybe. I think the European bit is interesting in the sense that the divergence, to the extent it can be observed, is more on the remedies bit. So the agencies, I'll actually throw US in that mix a little bit too, to the extent an issue is raised, there is a convergence. And you can ballpark guess that these agencies are going to flag an issue or not, if their markets are impacted in a similar way. Where you really get sucker punched is with the remedy negotiations. I'm just looking at a list that I quickly prepared. So on Cargotec, Concurrences, you have, this is 2022, the US and the UK, so CMA, rejecting the transaction, US rejecting meaning threatening to sue, so, it going haywire, whereas EU remedies were accepted. You have January 2022 Meta customer rather, and you have in the EU 10-year API access commitments being negotiated, whereas you have a simple clearance in the UK. First, in September 2021, you get the clearance in the UK from the CMA, and then the EU Commission is accepting with commitments. You look at the S&P IHS of February 2022. In the S&P matter, you're also looking at a divergence because there are two different sets of remedies. If you wanted to use a slogan, both agencies, both the CMA and the EU Commission have accepted it with remedies, you might say. But the remedies are so far different from each other that these are completely two different punches on the same transaction. What am I trying to say? I think what I'm saying is, one, it is dead clear that after the Brexit, we're looking at a much more unpredictable merger control regime globally because we have another player that is coming up with a whole separate line of enforcement priorities. So, and also you can't characterize it in a comparable fashion either. You're unable to say, so the CMA is always taking the harder stance. It's not like that. There are instances where the CMA is actually breezier in its analysis, and then the EU is flagging an issue, as it is the example in Meta customer, for example. So I think, long story short, you end up in a situation where, if you throw in China into the mix as well, you are really looking at very many agencies that are going to throw at you completely different sets of concerns, which in turn means, I guess, that someone like Julie or Jesús, when they receive a flesh and bone person in their office saying, so how long would it take? It is a very deep analysis, and I guess this is going to be the trend. More and more jurisdictions are going to follow suit. Some of them, unfortunately, without the equipment to follow that suit. So some of them don't have the economic analysis tools, but they love to throw in these theories of harm that need to be backed up with economic analysis, but they're just basically subscribing to scaremongering, and there are narratives, but not enough number crunching. Some of them, like the ones that we have mentioned, have the sophistication to come up with those theories, but their theories don't match each other. And some of them, some of these cases are making you feel that there is something wrong with this divergence, because it just cannot be that in a transaction like Meta Giphy, for example, there would be completely different sets of analysis in neighboring markets. That there has to be one theory of harm applicable in these. Okay, Brexit did happen, but ultimately this is a technology-related market, and the transaction relates to a product that is being used exactly the same way in these markets. So you couldn't talk about a completely different dynamic of the marketplace. And the theory of harm that is voiced in one of these jurisdictions should have been applicable in the other jurisdiction as well. So someone's getting it wrong, basically. I think part of it is that there is a race to be more cutting edge among all jurisdictions, by the way, and that's a risk factor of the emerging markets competition agencies as well, because they want to do AI-related enforcement as well. Yet they're not the originating jurisdiction of that technology, and they don't have the engineering understanding of what the repercussions of that kind of a ramification would be and all that. Partly, I think, also the CMA is now making its presence felt in a way that is closer to the US approach to matters, which is that some deals must be rejected, is the CMA approach. You know, sometimes I'll just not play ball. That doesn't look to be the EU way, at least yet. In the way the Commission is conducting itself, there is a remedy to issues if we take
And the processes are different.
Yes.
So you can get more leverage from the time.
When we talk about the processes, obviously the US also is an interesting issue, because the way the procedure works in the US makes it an outlier in certain transactions as well. But in the EU versus the UK...
Because we have due process. Sorry, I couldn't help myself.
In the EU versus the UK bit, I think one particular issue that one has to observe is that the UK sometimes openly says it's going to take too much time and energy to monitor this remedy. I'm just unwilling to accept it on account of how complex it is. In my view, the Commission is more cognizant of the fact that especially if we're in fields like innovation theories of harm and all that, this is going to require a more innovative approach in and of itself to remedification as well. So I can't make do with my usual expectations of let's deal with the unilateral effects and be done with it. So talk to me about structural remedies. And they are a bit more accommodating, in my view. Good or bad, but the CMA has thresholds, and if you go in with a remedification package that is too complex to monitor, that's in and of itself a reason to check out. And that's accounting for part of the divergence, in my view. We did. So the CMA just 7 hours ago released its initial report on the foundation models. Foundation models are the generative AI that is functional in different ways, but with a market impact. And they have been looking into it since May. There was a release in May that they were saying in September we're going to come up with a report and we're going to put forward our priorities. They did that today. I've reviewed it to the best I can before coming in, and basically they're proposing guiding principles, and they're proposing that AI is going to be an important aspect of enforcement, or focus rather. In the guiding principles, when you look into them, accountability, access, diversity, choice, flexibility, fair dealing, transparency, they may sound too broad, but they are filling what it is. It is also, there are similarities with the blog post of June 29th in the US. And you can see some common themes as well. That's the CMA bit. At the same time, you can also see that in the EU, the Commission is looking into AI matters closely, which is not a surprise really, because you do have the Digital Markets Act, and the Digital Markets Act is dealing with gatekeepers, particularly, among other things. And when you think of what is the source of market power and concern in AI, you would come up with financial resources, right? Especially if you put in computational resources and cloud access issues in there. Then human resources, also engineering resources, and data resources. All of these resources are most abundant with the gatekeepers. So when you're dealing with the Digital Markets Act, you're also dealing somehow with the AI concerns already. I would agree that part of the AI saga is going to be the price-related matter. There's actually an interesting European touch I would like to bring into this recent discussion that we're having in this panel. There's European Commission's e-commerce sector inquiry of 2017. And it revealed that about 2/3 of EU e-commerce retailers, i.e. most of the e-commerce stores basically, use quote-unquote software that allows automatic adjustment of prices to match those offered by competitors. More than 2/3. Now, this was 2017. All that it takes is more of generative AI taking the lead in that software capacity, and then the rationality of price-following behavior becoming a little too collusive in the hands of AI. It almost looks like an automatic risk. So I would also mark, as my fellow panelists did, this as one cause of concern. But I would also go for exclusive dealing or discriminatory behavior funneling users toward the dominant company's own generative AI. I think that's also going to be an issue. And then there's AI and merger control, which is going to be interesting. One, AI itself is going to change how we perceive merger control matters, in the sense that, for example, when we look at a merger control matter, we're using concentration-based analyses, HHI index, for example. In certain instances where algorithmic collusion is so easy, HHI index won't cut it, probably. And we're going to say, yes, there are very many players, but in terms of algorithmic collusion potential, this transaction increases it significantly. So I still would like to look into it as a separate issue. Also, in merger control, market asymmetries typically bring comfort to us. We believe that if there are asymmetric competitors available, they are unable to predict each other's behavior, which makes the market less transparent, so no more conducive to genuine competition. Not so much with more AI being injected into some of these markets. It will be easier to follow the patterns of your competitors and react to it. And ultimately, in the AI markets, I think there's going to be a ball game of nipping it at the bud. This is something we know from other markets anyway, so I don't think I'm saying anything particularly interesting and only belonging to artificial intelligence, but also AI markets are going to be those types of markets where big players will want to go after promising AI companies. This was the concern with Microsoft OpenAI, for example, or their stake in ChatGPT, and whether they're using other techniques to foster the prevalence of ChatGPT. And these kinds of things, so killer acquisitions in the AI sector, if you will, are going to take our attention in the near future, I would predict. I would agree with Julie said, what Julie said the last, which is that my key takeaway would be that markets are changing so interestingly and rapidly, and this change is happening exponentially as it happens with technology, that I think antitrust lawyers are always going to be quite busy with new ideas and new thoughts. I was thinking about that when I just casually checked if there's anything new from yesterday to today that I should report to you, and I found, the CMA initial report is out. So I think antitrust is going to be that kind of a field for the students of today, the younger lawyers of today, and for us as well, that it's going to be a challenge to be entirely updated. And it's also going to be very interesting to follow, especially the developments in the artificial intelligence sphere and how the overall regulation debate on the data protection side and on the safety and security side has a bearing on the antitrust regulation of the same.